On the phone, it's a pleasure to welcome to the program Richard Kim. He's the executive editor of thenation.com. Welcome to the program, Richard.
Hi, Sam. Thanks for having me on.
Richard, let's get a little bit remedial here in terms of the Defense of Marriage Act. By now, I think if anyone's not aware that it was found unconstitutional by the Supreme Court, then I'm surprised they have the capacity to listen to this. But let's go back. Give us the history of the Defense of Marriage Act, because I'm not. Or let's start with what it is, or what it was, I should say.
Right. Well, there are actually several parts of the Defense of Marriage Act, and the part that was struck down yesterday is Section 3. And that's the part that says the federal government doesn't have to recognize marriages that are performed, same-sex marriages that are performed in states. All of this was passed in 1996 and signed by Bill Clinton, and his argument about why he passed the Defense of Marriage Act has always been that he was trying to forestall a federal constitutional amendment, which would be much more difficult to remove. And as we know now, Clinton a few months ago said he no longer believes in the Defense of Marriage Act and had urged the justices to repeal it. So Section 3 is what has been struck down. There are other sections of the Defense of Marriage Act, and those say, for example, that other states don't have to recognize marriages performed, let's say in New York. And that is still on the books and is an obstacle to marriages being recognized in all 50 states.
All right, let's deal with that issue. I mean, how, from a legal standpoint, I mean, it seems to me that this decision was based less on a states' rights principle and more on a equal protection principle. How, if that's the case, and maybe that assessment is wrong, but if that's the case, how is it that the other sections, particularly that section in terms of some type of reciprocity between states, how is it that those can stand?
Well, that section was not challenged in this particular lawsuit, so it wasn't even up for question. The decision itself was in part deference to the states. I mean, there was an argument advanced by the lawyers in the Windsor case, as well as by Justice Kennedy, that there should be deference given traditionally to states' marriage laws, and that has consistently been the principle. But there also was a very strong equal protection element to the decision, and you could read the tea leaves there and see that Justice Kennedy was really laying down, I think, some precedent to challenge these other laws. That litigation will definitely happen. It's already happening on the state level in Nevada, for example. These cases will go forward, and I think one day soon, in the next 5-10 years, the Supreme Court will hear a case about the constitutional bans on marriage that exist in 30-plus states now.
So is that? I mean, give me a sense of what you think from a strategic sense on what we will see in terms of these cases. What cases are already in the pipeline? Will we see cases first bubble up in states that have no constitutional, whose constitution does not in any way reference a marriage as being between a man and a woman? Will we see states that simply will be challenged in terms of that make no mention of it at all, but don't recognize the marriage, let's say, right, from New York? Or what do you think the order of these things will happen?
Well, so the lowest hanging fruit here is there are 8 states: Hawaii, Indiana, Illinois, New Mexico, New Jersey, Wyoming, Pennsylvania, and West Virginia. Those states do not have a constitutional ban on same-sex marriage, but they also don't have same-sex marriage. So there's a chance there legislatively to push through the recognition of same-sex marriage, and that in fact has already taken place in New Jersey. It's been vetoed by Chris Christie. Illinois is working on legislation. New Mexico is working on legislation. Hawaii is working on legislation. So that is the sort of lower hanging fruit, and I think gay and lesbian advocates are optimistic that they could score those wins in the next few years. Now, the states that have these marriage bans on the Constitution, in their Constitution, that is a very tough nut to crack. Repealing these bans often requires 2 separate sessions of the legislature to repeal it. It has to go through twice. And most of these state legislatures are dominated by Republicans, in some states with veto-proof and filibuster-proof majorities, or it's going to take a popular referendum. And these are deep red states like Oklahoma, Alabama, Texas. Interestingly, a lot of the states that are now moving forward, thanks to the Voting Rights Act decision to restrict democracy for minorities. So there's a really big uphill battle there in terms of, on the state level, getting rid of these bans. There could be a sort of legal magic trick that happens where a marriage that was recognized in New York, but it's not recognized in Oklahoma, that someone brings suit, and the courts rule that Oklahoma has to, recognize these marriages performed by other states. But, given the ruling the other day, that it does not seem likely that the court right now, at this moment, wants to tackle that question. I think they will have to in the next few years.
I want to get to the material benefits that come with a federal recognition of marriage, but before we do, give me your sense of. There's two strategies here, right? In terms of these states that have these bans on same-sex marriage or don't address them at all, and I wonder and perhaps it's irrelevant, but I wonder from a societal standpoint, from a sort of a sense of how society adopts these, sort of accepts same-sex marriage, which has evolved incredibly fast, at least in this narrow period of time that we're looking at. Obviously, there's been something.
The majority of Americans now support same-sex marriage, and that is a phenomenal change just in the last few years.
So, do you think that it's important that this happen through the courts or through legislatively? In other words, if there's a perception that this is just this is about just about rights that are sort of innate to people in terms of equal protection, as opposed to sort of this is something that we're statutorily recognizing. Is there a difference there?
There is a difference theoretically. I think in practice what has happened is that the two have worked hand in hand. That litigation has been a very important strategy. That's why same-sex marriage, for example, is legal in Iowa, of all places, and has been legal in Iowa for several years now. But I actually think the grassroots initiatives, the grassroots push, is the most important thing. People like to say the cliche that rights shouldn't be up for a vote. But in fact, they're always up for a vote. They're up for votes from Congress and from state legislatures. They're even up for votes in the Supreme Court, which in fact does vote on these matters and exists in the broader culture and society and is influenced by that. So, I always say that actually the best thing to happen to the gay marriage movement was the loss in Prop 8. That was in 2008, and people became agitated, motivated. They became protagonists of their own story. They didn't wait for the lawyers to show up or for the cases to go forward. They went to their neighbors. They went on the radio and on TV, and they started their own grassroots organizations. And that push really inspired thousands and thousands, millions of gay Americans to come forward and to make a case for their rights. After that, you saw state after state pass gay marriage: Minnesota, Maine, for example, Maryland, and these states did so democratically through the legislative process. President Obama made a change that I think was definitely influenced by the shift in public opinion and the concern for his future political legacy, and all of that fed into the decisions that were reached yesterday. They created and I think it's the right perception that history is only going one way in this direction, and it's clear that Justice Kennedy wanted to be on the right side of that history.
Just outline for us sort of the material implications in terms of a federal recognition of marriage. It really is so broad based that it ranging from Edith Windsor getting, I guess, a rebate check of $385,000, which, of course, not what this is about as much, but in some respects, it's another one of those things where the legality sets the framework for the acceptance of equality.
Yeah, well, there are hundreds and hundreds of federal rights at stake, including, rights about taxation, Social Security benefits, Even, for example, there laws about state parks and entry fees into state parks regarding whether or not you're married. So there are hundreds and hundreds of these statutes on the book. The interesting thing that I'm looking at now is how the Obama administration is going to interpret this decision. They've convened a special task force at the Department of Justice to look at the hundreds of ways that they will have to change federal statute, either through executive action or changes within agencies, or in some cases, I think acts of Congress will be required, and that's going to be a tough haul given the Republican control there. But it's not immediately clear, that the decision overnight gives all of those benefits to same-sex couples. For example, the IRS looks at the state in which you reside. Right. So if you were married in New York, a state that recognizes same-sex marriage, and you move to Alabama, a state that does not, currently the IRS is not going to recognize you as a married couple. The Obama administration wants to change that. The Department of Defense, and this is one of the weird things here, they look at the state where your marriage was performed in. Already Chuck Hagel has said that they're going to recognize marriages that were performed in New York, even if you now live in North Carolina, for example. But there's going to be a very meticulous, very arduous process to comb through all the federal statutes and all the agencies and change the laws and regulations so that same-sex couples who are married in the 13 states that recognize same-sex marriage will have their marriage rights recognized no matter where they end up living.
I mean, it's sort of fascinating that there were all these idiosyncrasies in the law, which, of course, nobody really paid attention to that much because it was immaterial more often than not. I mean, I guess that's what sort of this represents. Now it is relevant where you were married, where it may not have been before.
Yeah, the marriage law is actually very, very complicated, and there's jurisdiction that states have. There's the question of the full faith and credit clause. Are marriages performed in one state legally recognized by another? And the precedent there has traditionally been to give states some deference in constructing their own marriage laws and recognizing some marriages and not others. And then there are all the 1,000-plus federal benefits that accrue. So it is, a very complicated map. Straight people didn't really have to pay attention to this and don't. Someone like Edith Windsor absolutely did. And that's why, I saw her talk yesterday in front of the Stonewall Inn after the decision, and she said that when she discovered that she was going to be taxed just because she had married a woman, if she had married a man, she would not have been taxed $300-something thousand. Her sense of injustice and unfairness overwhelmed her, and that's why she brought suit against the federal government.
Yeah, it's just fat, and I would recommend people just Google her. I mean, her story is really stunning.
She's an incredible heroine.
Yeah, it really. I mean, it's an amazing story, and I mean, unfortunately, people had the opportunity to see her on TV over the past couple of days. Let's talk a little bit about the beginnings of DOMA, because and maybe some of this may be moot, but I think it's important that people understand the context in which DOMA came about. Are you skeptical about Bill Clinton's claims that DOMA was at least primarily an attempt to head off a constitutional amendment, a federal constitutional amendment, or was it more about sort of the political machinations of the time?
Right. I don't doubt at all that there was a movement to pass a federal constitutional amendment banning marriage. This is, in fact, something George W. Bush championed when he was president.
Which I got to say, it was one of the most, of all the moments during the Bush administration, was one of the most chilling moments. I mean, I think I've said this before on this program, but I found it to be one of the most chilling moments in my adult life, watching the president go on television and say how sad he was that he was going to have to promote discrimination against a group of people in our country. I mean, that was just sort of stunning.
Yeah, I mean, well, he also said that same-sex marriage would be the end of civilization as we know it. So I'm waiting for that end of civilization to happen today.
There are parts of Massachusetts
now that the federal government recognizes marriage.
Coming from Massachusetts, there's parts of it. I don't know if you've been to Lowell, but that's. I'm sorry. I'm making a Massachusetts joke. Go ahead.
But the thing is, back in 1996, there was fear. Hawaii had passed briefly. The courts there had recognized same-sex marriage briefly a few years ago, and there was a fear amongst the right wing that once one state passed same-sex marriage, all the other states would have to recognize it. There definitely was a push by right-wing advocates for a federal constitutional amendment. Now, the question is, could we have defeated that without passing DOMA? A constitutional amendment, as we know, is incredibly difficult to get into law. It has to pass through 3/4 of state legislatures, and there's a thinking on the part of some gay advocates that they would have welcomed actually that challenge. Let's then put this to the vote. Let's force all these state legislatures and politicians to go on record saying that we want to discriminate against gay people. It would have been a tremendous drain of resources from the Christian right. And so I don't think Bill Clinton needed to pass DOMA in order to forestall the amendment. Was he acting in political self-interest to kind of just make this issue go away? Absolutely.